Well, hello everybody. Thank you for joining us on our first actual SLG webinar. Today we have and are going to be interviewing our special guest, Dave Singh, who is the principal attorney here. So yeah, I'd like to introduce Dave. Dave, how are you?
I'm good. I'm good. How's everybody doing this morning? Great. Everyone's
Great,
on mute.
great.
Fantastic. All right. What are we talking about today, Gavin?
All right. So our specially picked out topic for this first webinar is estate planning for millennials. So
Awesome.
we hope you have something good for us.
Absolutely. Yeah, no, it's a great topic. We have our team is actually composed of millennials, quite a few millennials, including myself. No laughs, please. I'm right at the top of that generation. So this is relevant to many of us here. When we think about estate planning for millennials, and I know we're going to get into questions, but when we're thinking about these things, what's the difference between planning for millennials versus planning for folks who are, a bit more elderly, or folks who are, looking at different circumstances. Maybe they are in an incapacitated situation, or they're taking care of children with special needs, or parents that are in those situations. So different sets of considerations. The tools are very much the same. So the things that we think about with millennials is, where are they in their journey in their life? And so often when we're approached by a family or an individual who is of that age, right? And so this tends to be at the low end, it's like late 20s. At the top end, it's about late 30s, early 40s. That group of folks is what is considered millennials. And that actually covers quite a bit. So at the younger ages, we have folks who maybe they're progressing in their careers. They may have just finished up grad school. They're starting their jobs. They're starting to actually accumulate some assets. And so when people generally, when they start to accumulate assets, they start to think about, how do I plan for those assets? How do I make sure that they go to the right person or people? And often for that group, they don't necessarily have those people necessarily yet. So they may not have children yet. They may not have a spouse yet, but they still have their parents. They may have siblings. They may have other family members. We often see things left to friends for that group of people. And so those are the differences in terms of how we think about structuring, is that we don't have the ability to incorporate children just yet for some of the families or some of the individuals that we work with that would be considered millennials. There's another, I would say, larger group of folks that contact us who are starting families. They're both, really gaining some traction in their careers. This is now, a married couple, and starting to gain some traction in their careers. They may have had their first child, or they're expecting. That's always fun, to work with families that have that excitement going on around them. And so what we're thinking about there, and what some of the most important things that we're thinking about are, what do we need to have in place so that this family feels comfortable either bringing a child into the world, or taking care of and making sure that they have the right pieces in place for the young children that they do have. And so top of the list is generally guardianship, and making sure that guardianship is very, very clear in the event that something happens to one or both of the parents. And so that's really, for millennials, we found the highest priority, and that's what our recommendation is as well, is let's make sure that guardianship is really clear. Now, beyond that, what we want to build into the plan is a good amount of flexibility, because they are of a younger age. We want to allow room for their plan to adapt. There may be additional children that come along. Careers can change, where they live can change, lots of different things can change in their lives. And so we don't want to tie them down to something that's too rigid. And so we're not typically, with some exceptions, but we're not typically talking about structures that are more rigid, like irrevocable trusts, when we're working with millennials. Typically what we're recommending is what's called a living trust, a revocable trust, revocable living trust, putting that together. So this is the really common term that many people are familiar with. And essentially, that's a vehicle that we create for these families to hold their assets, provide a roadmap for what we want to happen with those assets, but also provide clear instructions as to these are the people that we want in the driver's seat. If we're not able to drive, these are the backups to those people. So we have passenger seat as well. And like I said, all of this is built out in the roadmap, which is the actual trust document. The nice thing about revocable trusts, living trusts, is that they have a high degree of flexibility, as much flexibility as we could have in this area. And so when we create these documents, they can be changed by the spouses working together or individual. They can be adjusted as long as that person has the ability to continue to make decisions. So as long as they're not sick or incapacitated and they're still around, they can make those adjustments. So we really like that solution because it does eliminate the risk of probate court, which is always kind of the thing lurking in the corner. We get rid of that. And so there's no probate court risk. And now we've created this structure, this vehicle that can be adjusted as their life goes on and as life events happen. So really, in terms of planning for millennials, those are the things that we look for. How much flexibility can we create? And then very, very commonly, the most important thing, the thing that kind of, overrides everything else is how do we plan for the minor children? How do we take care of guardianship? So as a starting point, I think that's a good time to jump into any questions that you might have.
All right, awesome. Well, thank you for that very detailed description. You answered about 9 of my questions that I had.
How many questions do we have?
We had 9.
Oh, we had 9. Excellent.
No. All right. Well, so awesome. Let's jump into some questions, and a lot of them were actually submitted by our team. One thing, since you're on the topic of guardianship, what I didn't hear you mention is pets. And I know a lot of my friends and people in my age range, they're kind of steering away from kids right now, but they all have pets.
Mm-hmm.
So what happens to their pets?
Yeah, great question.
How do they protect their pets?
Absolutely. So great question and really important question. And I think, many of us here on the team, do have pets, and some of us have our own social media profiles for our pets. So this is very timely kind of topic. So when we think about pets, and this is going to be strange to say, but in California, pets are considered property. And so we plan for pets the same way that you might plan for your vehicles or, the watch that you inherited from your grandfather, right? Pets are actually considered, they're within that same category. They are considered property. And we don't think about them that way, right? We think of them as family members. So in California, what we're able to do is create a pet trust, which is actually what's called an honorary trust. It's not really legally enforceable, but it's something that is, we can create structure around it. And so the way that works, and I'll use our pets as an example. So we have Ziggy and Marley, 2 twin Malteses. So if we wanted to create a trust for them, what we would do, and this is set out in our trust document, essentially what we would do is we would have a section in the trust document where we're identifying our property, right? The pets. We are identifying Ziggy and Marley, the 2 twin Malteses, barely touching 5 pounds each. And so, but we would identify them, and then we would say, for these pets, we are nominating the following person as trustee. And so what we're actually doing is we are giving a gift, or it could be a recurring gift, to that person who's nominated as the trustee. So I know Indira, as an example, she loves our pets. So, we would nominate her as the trustee, and we would say on a monthly basis, we're going to leave $200 a month to buy food and, other necessaries for the dogs. And if there's anything extra, Merry Christmas, that type of thing, right? So anything extra you can keep, but we're kind of building out that, those recurring gifts and building out a trust. So we're naming somebody who's responsible, but we're also providing resources to support that as well. And in essence, it's like a gift, but we're basically what we're doing is creating a format or a framework for those pets to be taken care of for the rest of their lives.
Okay. All right, understood. And where does that, since we're, still here, where does that money come from? How does
Yeah,
that
sure.
money go to the trustee?
Yeah, great question. So this is the importance of trust funding. I'm glad this came up. So one of the big things that our clients that we advise our clients, and then sometimes we meet clients for the first time, and they have not taken care of this part of the process, is what's called funding. So funding is, we've created this vehicle, and now we want to make sure that we've put assets into the trunk of the vehicle. Otherwise, we have a vehicle here and we have assets here, and then they're not connected. And so it doesn't really solve the issue. It doesn't eliminate probate court. A lot of the issues that we're trying to solve for still remain when these two things aren't connected. So what we want to do is make sure that the assets, which could be bank accounts, real estate, etc., that they are placed into the trunk of the vehicle. That process is called funding. Now, once we've funded the trust, we've put those assets into the trunk of the vehicle. Now, those assets will abide by the rules that we have set forth in the roadmap, or the set of directions that we have left in the roadmap. So if we direct that the trust funds be used, for example, for Ziggy and Marley's pet trust, then the trustee, the person in the driver's seat, is responsible for making sure that that's what happens with those assets that are in the trunk. But if those assets are not in the trust, then that driver is not going to have the ability to do that. So it's a really important step, and it's what makes the whole thing work.
Okay, got it. All right, awesome. So now I know what will happen with my pets. All right. I do know, moving on, I know a lot of people in my age range, and me specifically as well, are trying to buy houses right now, right? So should we be thinking, like, should a living trust be something that's on our mind while, we're trying to also save to buy a house? When's the right time to be thinking about a living trust, in terms
Yeah.
of buying a home?
Yeah, great question. So with millennials in particular, that's the group of folks that we work with, that has the highest percentage of individuals. So as we get into some of the older age ranges, typically we're working with married couples, but at the millennial, within the millennial group, that's where we'll have the highest concentration of individuals. So what that means is we're representing someone who is not married yet. They may be contemplating marriage. They may not, right? These things are all personal. So if we're representing an individual and they are buying a home, one of the things one of the risks that we have is that if they take title to that home in their individual name and something happens to that person, there's only one person on title, that individual, and something happens to that person, then we're going to have a probate issue. And so essentially that's what we want to avoid with, by creating a living trust. And that becomes especially relevant when we have individuals. So someone contemplating buying a house can create a trust before they actually purchase the property, leading up to that purchase, or we recommend it. Often we'll do it actually during the escrow period. So someone will open escrow on a house. That's typically 30 to 45 days. That's plenty of time for us to get something in place. And then when the house closes, it goes right into the trust, and it goes right into the that vehicle. So that's a nice timeline for us, and I think it makes sense for our clients.
All right, got it. So that's like a general turnaround time that anybody, not only millennials, could expect, working with your firm and getting a living trust, about 30, 35 days.
So that's a really good question, and it's something that comes up a lot, especially with clients who are facing medical decisions, or sometimes it's just clients who maybe they have a trip planned and they're going to be out of the country for 3 to 6 months, long-term travel types of situations, or even shorter vacations. Like, why is this relevant? So we like to stick to a 3 to 5 week timeline for our trust, in terms of, someone becomes a client, or say, family married couple becomes a client, And then within 3 to 5 weeks, we've completed their plan. And that includes us going through our discovery process with them, getting the information that we need, going through the design process. So we are putting the components, kind of structuring the way that their plan is going to work, drafting the actual documents, reviewing, and then executing. All of that, we like to see it happen within 3 to 5 weeks. Now, there are, and that I think is a nice, healthy timeline, and it gives a good amount of space for these decisions, these important decisions to be made. Now, if a client has a more accelerated timeline, or if they have a more accelerated need, so for example, I'm going into a medical procedure at the end of this week, it's Tuesday, and I'm calling SuccessionLegal, and I need this to be done. I mean, we have done things like that. It's not ideal. I don't like to accelerate those timelines unless we have to, but we are very effective in those circumstances, and we can complete things very quickly. So as quickly as I think there was one situation that we had to complete a plan within 4 hours. So, and we did. We are able to do that. We do sacrifice things in terms of process. We don't get that time to kind of allow the client to marinate on decisions and make adjustments at that stage, but it can be done. So, but that said, I mean, really what we want to stick to is about a 3 to 5 week timeline.
Okay, got it. Good to know. You did mention marriage and getting married. I did have one question I wanted to ask. So I anticipate getting married within the next few years. And a lot of my friends do too, people that I hang out with. Should I wait until I get married to get a living trust? That way, it's with me and my wife, or should I do one now as a single person? I don't want to pay twice. That's what I would like to avoid, but you also never know what could happen.
Right. No, really good question. So the reason you would think about forming a trust, establishing a trust before marriage, is if you have accumulated some assets before marriage that you would want to keep separate. So taking a step back, California is what's known as a community property state. And so what that means is once two people become married, there is a bucket that is created between them, and it's called the community bucket. We would think about it's community property. And so everything that they accumulate after that date of marriage, everything that they accumulate is really going into that bucket, unless there's some agreement otherwise. And that's where we have prenuptial agreements. We can even have post-nuptial agreements. So these are agreements after marriage to treat property as separate from that community bucket. There's a lot of nuances to this, so we're going to keep it really high level, but essentially when we think about going into marriage, each individual has a separate property bucket that they're going into the marriage with. That's all the stuff they have before they got married, and whatever that is. And that may be a lot, it may be a little, anything in between. So they have those two buckets going into the marriage. And when we have clients that have substantial assets, and it's usually it's clients who are getting married a little later in life, or it could be a second marriage, third marriage situation. They might have substantial assets in those separate property buckets, so the pre-marriage buckets. And so going into the marriage, what we would recommend is to have a prenuptial agreement, but it's supported by a trust for those separate property assets. So we create a trust just for those separate property assets, but what keeps the whole foundation tied together is the prenuptial agreement. And then the clients will still have their community property bucket that they can continue to build into during their marriage. That's all fine and that's great. But what's separate is separate, and what's together is together. So, what I would say is contemplating marriage, going into that engagement period, probably one of the last things that people want to think about is the legalities of it. But what we like to do is we like to kind of get in and get out. We come in, we take care of the legal stuff, the stuff that's not necessarily pleasant, get it taken care of, and then get out of the way and let our clients enjoy the rest of their engagement period, and then and their wedding and marriage. So that that's the role that we play in those situations.
Okay, great. All right. Well, I do see, our time is coming to an end soon. So I want to thank you, for, answering all of our questions. I'm sure whoever views this, is going to get a lot of great information from this. I do have one question though, which would lead us into our next topic of our following webinar. But can I pay you in Bitcoin?
Excellent question. To be discussed. So no, yeah, that I'm looking forward to chatting about that next week.